Welcome to a place where real courtroom scenes happen live. Today, Judge Raquel West takes her seat, a name that carries authority and action. From payment disputes to felony pleas, this session is packed. Let's head inside.
And this is 24 DCCR 1914. Mr. McCorvey is charged with theft of property, and what is the announcement?
Judge, this was the one that it's taken a while to get some things from a probate court, which we did by the last setting.
Right.
It was reset because we was trying to confirm restitution amount with the complainant. She won't talk with us. I think the issue is Mr. Hoffmeyer is going to try to get with the investigator, see if they can confirm an amount, because basically the restitution was going to resolve the.
Right.
Correct, Judge, and the notes, according to Mr. Hoffmeyer, are that based on that probate order, just a very short conversation with the complainant. Now, if we have that transcript, should get us to a figure that should be able to resolve.
Okay.
And I can make sure that.
If you would, because that's where I thought we were last time. And so if you'll get with him and make sure Mr. Hoffmeyer gets on that quickly so that we don't have another reset based on that, please,
I will,
ma'am.
Judge. I'll
Thank you. All right, stay in touch with Mr. Lewis and he'll let you know when you need to be back. Good morning, you're Ashley Sanders. This is 24 DCCR 1650. We were waiting on audit.
Here's something to notice. This discussion about restitution isn't just paperwork. It's about taking responsibility. When victims stay silent, it slows justice down. Judges like West must balance patience with progress, pushing for answers without losing control. That's skilled courtroom handling.
Judge, I'm happy to announce, thank you for the court being so lenient with us and resetting this a few times. Mr. Wimberly is actually here this morning with his client, my complainant. They did send me some documentation just right before docket. He's also indicated that his office is this week making notebooks for Mr. Kelly and myself and having everything scanned in. If we may just have one final, now that we have all that information, hopefully we can I can sit down with them, then Mr. Kelly and I can sit down and discuss it and see where we are. We'll be ready to finally announce next time. But I did want to confirm we do have all that documentation, or
Okay.
it should be to me this week.
All right. Thank you, Mr. Wimberly.
Right.
All right, so what I'm going to do,
And if you want to go ahead and put it on the trial docket, Judge,
no.
I certainly would understand.
Yeah, no, I just want to, let's see.
My only concern when I hear notebook is.
That's what I'm thinking as well.
What we're talking about.
Yes, sir.
We'll be about that thing.
Okay.
With all the tech.
So why don't we do this? When we come back next time, I want it all done and I want an answer. And so what I'm going to do is reset it to the 1st of January. That should be about a 60-day, a little more than that. I want everything hopefully turned over this week. That gives you an opportunity. So unless there's something else that comes up, I want it all gone through in an announcement at the next court date.
Yes.
Okay? All right, you're free to go. Thank you, sir.
Thank you.
Thank you, Mr. Kelly. Good morning. Are you Ryan Hodge?
Yes, ma'am.
And Mr. Hodge is charged in cause number 24.
A 60-day reset may sound routine, but it's really a ticking clock. Everyone now has 2 months to gather proof. In criminal court, time isn't kindness, it's pressure. The next session will show who prepared and who didn't.
CR 1167. With the third-degree felony offense of evading arrest or detention with the use of a vehicle. The indictment alleges a prior burglary from 2015, and then also felony of bribing an officer in 2018 and possession of a firearm by a felon in 2018. We had reset that as well, some other stuff as well.
Those are out of state.
Yep. So what that means, though, is for punishment purposes, if Mr. Hodge, if you're found guilty by a jury, you would be considered a habitual offender, which means your minimum punishment, if you go to trial and are found guilty, is 25 years in prison, up to 99 years or life in prison.
Now the tension rises. Meet Ryan Hodge, facing a repeat offender upgrade in Texas. That title changes everything. Minimum 25 years, maximum life. When the judge reminds him of that, it's not advice, it's fact. Every sentence spoken could decide his future.
You understand? And we reset this case for you guys to watch the video, and have you had an opportunity to review the video in this case?
I've seen it prior, like, version.
You seen the video?
I think
Yeah,
he's
I've
seen
seen
it with his prior.
Okay,
previous
so you've
attorney.
seen the video, and have you talked to Mr. Kimler about it? Answer out loud.
Do I know?
You
Have
see,
you
we
s-
talked about the video.
We've talked about it, yes, ma'am.
Okay, and I want to make sure, so I have here on the tablet a plea bargain rejection that shows that the district attorney's office has made an offer, if you wanted to enter a plea of guilty, to go on count one only, which is just the offense of evading arrest or detention, not those prior offenses, for a cap of 10 years, which means you would leave your punishment up to me. I can give you 10 years, I can give you less. It would depend on the information that was brought to me at a sentencing hearing. You have every right to reject that and have your case set for trial. I just want to make sure you understand what your possible consequences are and what your options are. And do you understand all of that? And so I'm also making the notation here on that plea bargain rejection that I've admonished you as to what the minimum will be if you're found guilty, which is 25 years in prison. You understand? And you want to reject that and have your case set for trial.
Yes, ma'am. Didn't want it, I was just being
He's maintained his innocence.
All right. Then I do want to make sure you understand that after today, I will not accept a plea agreement. I'll get your case set on the trial docket. There won't be a plea. We'll let a jury decide, okay?
So, for any reason, we can't look into it further, the facts and the evidence. That I
Well, that's what a jury's for. And so your attorney has discussed the case with the assistant district attorney. Their position is that it's an evading and they think they can prove that, and that's what we're going to go to trial. Okay? That's what a jury's for. All right?
Fire on the other. No.
All right, ma'am, you're Brianna Clanan. And will your client waive the formal reading of the indictment?
She will.
Ms. Clanan, in cause number 25, DCCR 0446, you're charged with the third-degree felony offense of evading arrest or detention with the use of a vehicle from March 8th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Kimler? Do you fully understand them? And do you understand if I follow the agreement that you've made with the district attorney, you will be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 3-year deferred probation. There would be a $250 fine.
I'll explain my scribbles, Your Honor.
Oh, that's CCCR. There would be
Yes,
a
there's
dismissal
misdemeanor.
in cause number 25 CCCR 1119, and this will run concurrently with 25 CCCR
1053.
1053. Is that your understanding?
There should be another misdemeanor.
It was refused.
Oh, it's refused. Okay.
And what are those
The
cases?
dismissed one is resisting arrest, and they're all connected to this, Your Honor.
Mm-hmm.
The dismissal is a resisting arrest. The case to be pled is a DWI.
Okay.
All out of the same criminal offense.
Let me look at something real quick. Oh goodness, I can't see that. If I test you this morning, will you be clean?
Be honest.
Have a seat in the jury box.
But-
Have a seat in the jury. Have a seat in the jury box. Let's get you tested.
If the court is willing to accept it after the PSI.
Okay, and she'll waive the formal reading of the indictment in each.
Yes, sir.
So, Ms. Randall, in clause number 25, DCCR 0246, you're charged.
That right there is a major shift. The judge just ordered a drug test on the spot. No waiting, no excuses. In court, your attitude matters as much as your past. One hint of lying, and a plea deal can collapse instantly.
With the state jail felony offense of theft of property with previous convictions. And that one's from November 21st of 2024. The indictment alleges you were previously convicted of theft April 4th of 1984 and April 11th of 1985, both misdemeanors, which would get us to the state jail felony level. It further alleges that you were convicted of a non-state jail felony offense of theft April 10th of 1989, and then again November 12th of 1991, and then after that was final, October 10th of 1994. And how do you plead to that charge? And are those prior offenses true? Or prior convictions true, excuse me. Are you entering your plea of guilty freely and voluntarily? And did you plead guilty because you actually did what they've charged you with? All right, give me just a second to get this pulled up so I can make that notation. I think that was 1 through 5.
Five or six, depending on how we want to look at it.